Hi friends, welcome back to my channel Shruti Desai's lecture on law. We are learning mediation. Before starting today's lecture, I just want to tell all of you that this is not the channel only for mediation. We will learn many other acts, as law is a field, huge field, and it's a sea of knowledge. So we will keep on taking each drop and learn something different every day and every month. We are learning mediation. Before going to the today's topic, I just want to also inform you that we are getting a lot of feedbacks and suggestions. We are working on it. My entire team is working on it. Till then, we will continue in the same fashion, and we will try utmost to satisfy all of you with all the guidances and all the suggestions what you give. For any further information, you can visit my website www.shrutidesai.in/. Do subscribe this channel and click on the bell icon. Now friends, last time we saw a joint meeting. It is called caucus also in our legal jargon. It's a legal jargon. Sometimes mediators do not like to, they hesitate to have caucus because it might, go reverse. So it's a strategic decision of the mediator to have joint meeting or a caucus. This decision is made by the mediator for positive progress in the matter. Mediators who avoid caucus are also sometimes worried about parties, suspicion that may develop within one or more parties when there is a caucus session going on. They might, doubt the integrity of the mediator. They might say that I never told you to, discuss on this point in a personal session. So it's a mediator has to be very careful before sharing any information in the caucus, and during this single session, the one-to-one personal meeting with each party, mediator has to repeatedly confirm, shall I share this information with the other party? Shall I share this information with the party? And thereafter only the mediator must share in the caucus such information in caucus. So this is this is the reason mainly why mediators are very alert, or they avoid or they delay the joint meeting after single session. What are the reasons of having caucus? Why mediators prefer? Suppose it's a strategic decision of the mediator. Why mediator go for caucus? Mediator do it with an intention to have a pause in the process. Mediator do it to have a creative pause in the process of mediation. When you sit each other, face each other in a room with a third party who knows your background, he has discussed your case with you, so it dilutes the differences between the parties. It's a psychological, basically mediation is a psychological game, and then it comes to the power of the mediation. We will come to that power of the mediators, but then it's a basically you have to understand the psychology, and after understanding the psychology and the case, mediator decides for caucus. So it dilutes the differences of opinion, and they will not divulge, they will not change their stand for the time being in the matter. Suppose it's a court in annex mediation, then they will not change their position in the matter. So they would also not take any harsh steps. Suppose a party has threatened with FIR, or in many divorce cases or child custody, or any other domestic violence. Mostly they go for FIR. So in such cases, they delay this decision of filing FIR. It is duty of the mediator to give a platform to offer settlement terms. This is also a reason for mediations, caucus, the joint meeting between the disputing party. It is caucus, another cause or a reason to have a joint meeting is to have an alternative to negotiated settlement. The mediator in this caucus, in discussion, we have learned that during these meetings there are suggestions, and there are terms are discussed, everything is discussed. So in this, mediator also assesses the realistic position of such suggestions, and then he makes both the parties understand what suggestion you have given. This is the implication. But suggestions are not given by the mediator. It is only party who suggests. Mediator is just a facilitator. I once again repeat, he is acting as a surrounding board, and in caucus he works to develop settlement proposal. He is just working to settle the dispute, and the proposals which are come before him, which are put up before him, he will just explain to both the parties, and he will further discuss the pros and cons of the suggestions given by the parties, and he will help in settling the matter in terms of the proposal put up by both the parties. Caucus also means generating information, which I said last time. We discussed last time that caucus is also for generating information. Now, what a mediator can divulge in this caucus? Mediator, I said just now that during the single session, mediator always asks, shall I divulge this to other party? Shall I share this to the other party? So mediator can share the information which he is permitted, or he has sought permission to share, or he has been asked to share with the other party. And mediator can share entire thing except which is asked not to share. So this is very important for a mediator to keep it in mind, that share only which is permitted, not everything. And also share which is relevant and which is asked to share. This is about this is how the caucus mediator has to be very alert in sharing the information. In either case, mediator has to continuously clarify, you had told me to share it. Am I right? We had discussed this to share, and as per what the Mr. X has said to share this, I'm sharing with you. This is what mediator has to be alert before sharing, or if he conceals something, then of course his integrity may be doubted. So be careful in sharing or not sharing the information, and stick to the instructions of both the parties in caucus. Now, what is the benefit of mediation? It's a confidential. Yes, it's a confidential, informal process, and mediator cannot be called as a witness. When in case of an arbitrator, he can be called as a witness if there are charges of fraud and dishonesty or biasness in the matter. So he can be called as a witness in the court. If the general expression of confidentiality, what we understand, is to disclose in plenary session that ought to be reserved for private session. So be careful as a mediator when you start next time, after learning from here or from somewhere else, be careful in sharing or not sharing the information. This question is asked that can the agreement or a settlement arrived at before a mediator can be executed? Yes, if it is court annexed mediation, and if it is settled, it can be executed as a decree. For further things, on this, we will come later on when we will discuss the recent amendment in Commercial Courts Act that we will discuss. Till then, goodbye. Stay tuned. We will learn again and again something new every day. If there is a holiday, we will also have a holiday. So stay tuned. Tomorrow we will learn principles and ethics of mediators. Bye.